Hello, welcome to this edition of the Stowe Family Law Breakup Club. Our topic for today is the family court. What is it and how do I navigate it? I'm Alice Price. I'm a senior associate solicitor here at Stowe, and I'm delighted to be joined today by Basi and Rhiannon Ford, who I'll come and introduce you to in a second. Just a couple of brief housekeeping points before we get started. You'll notice there's a Q&A and a chat box which you can use to put questions through. Can we try and keep them friendly? It's a safe space to put your questions, and it'd also really help us if you can focus on keeping your questions short and to the point so that we can get through as many of them as possible this evening. The webinar is being recorded and it's going to be on the Stowe Family Law YouTube channel soon, and a link will be sent out for that to you. We've had quite a lot of questions already, so we'll try and get through as many of them as we can. But if we don't get to your question, there are lots of different ways you can get in touch, and hopefully the topics that we cover will give you enough insight. If not, we can still send you a link to Stowe support, and you can get in touch with our client care department to arrange a call back and some more detailed advice that way. I'll start off just by introducing myself very briefly. My name is Alice Price and I'm a senior associate solicitor here at Stowe Family Law. My primary area of focus is financial remedy. So what that means is I deal with a lot of court cases relating to the finances, both inside the court system on a voluntary basis and through all sorts of different avenues that we'll touch on today, such as mediation, arbitration. I also deal with things like pre and post nups and disputes where people are unmarried but own property together. And the first panellist that we have today is Basi, who's a barrister at 4PB. If I could just hand over to you, Manny, to explain a little bit about who you are and your areas of specialism.
Yeah, thanks so much, Alice, and thanks for having me on this. So, yes, my name's Manny. I'm a barrister based in London, but I specialise in all disputes relating to children, both domestic and international. So the generic disputes that people often have when they can't agree on child arrangements, that's the type of stuff I deal with up and down the country. Thanks, Alice.
Thank you very much, Manny. And we're also really privileged to be joined by Rhiannon Ford. Rhiannon is a divorce coach and covers a lot of the things that Manny and I don't necessarily have the specialism in, but are also really important in these circumstances. So Rhiannon, do you want to tell us a little bit about who you are and what you do?
Yes, thanks, Alice, and thanks to Stowe for inviting me today. So I'm a divorce consultant and coach. I've got over 25 years experience in family law. I was previously a family law solicitor in another life, and I now run my consultancy service, which I've been doing for, it'll be 15 years next month, which is quite exciting. I provide help, support and guidance at all stages of the separation and divorce process. And one thing actually, which is probably particularly relevant for what we're covering today, is I also offer what's called witness familiarisation training for the family court, which in layman's terms is helping people to be prepared and feel calm and confident if they're going to be asked questions directly in court.
Brilliant. Great. Well, we've got a good breadth of expertise and hopefully we can get through as many questions as possible today in the time that we've got. We're scheduled to run for an hour, so until 6:30. And so without further ado, we'll start with some questions that we've had submitted in advance. So the first question that we've got is, my ex is refusing to engage or attend mediation. I think he's still processing the breakup as I instigated the divorce. I really don't want to go to court, but I'm not sure what other option I have for sorting out the finances. We have no children. Is this my only answer? I'll start by answering some of this and then perhaps I'll pass over to you in a second, Rhiannon, because there's two aspects to this question, really. From a legal point of view, if somebody won't mediate, then court is an option, particularly where you've tried repeatedly, perhaps a few different approaches to get someone to engage, but it's not the only one. So you could try, for example, having a solicitor's letter sent, whether that is to say, no, come on, I'm really serious about trying to sort this out. Can you come along to the mediation session? And then there are other kinds of alternative routes of dispute resolution that aren't just mediation. That's things like arbitration, and in some cases things like private FDRs that can be suggested. But a lot of the time it's sometimes a case of trying multiple approaches, and eventually you do find that you get a response come back. Even if you do find you have to start court proceedings, that doesn't mean that that's the only way you can resolve it. A lot of the time, judges will be willing to give you time to step sideways out of court, mediate for a little bit alongside to see if that helps to crack the answer once you've got that initial engagement there. So yes, court is an option, but I wouldn't say it's the only answer you've got. And there's a few other things in your armory there that you can try to get to the bottom of it. Rhiannon, I wonder whether you've got any insight in this.
Yeah, so I absolutely agree with everything you've said, Alice. I think a lot of people worry that if their other half is not engaging and cooperating right from the moment go, that it's going to be worst case scenario and they're going to end up having to go to court. And I think a lot of people don't appreciate that we do have lots of other options, as you've explained. So it's not just court or mediation. There are other options as well. What I tend to find, and I'm sure all of us here today do as well as professionals, is it's quite common for there to be the decision maker being in a different emotional state to perhaps the other person. So more often than not, it's one person making the decision to bring the relationship to an end rather than a joint decision. Obviously, sometimes it is. And sometimes then the person who is the non-decision maker does struggle to feel emotionally and mentally ready to deal with the divorce. So one of the things I was thinking of is perhaps if it's possible for the person who's asking us this question, for them to have a chat with their other half, with their ex, to see if they can sort of pull out what it is that's stopping them from moving forward, so that they can sort of establish, is it that they don't feel ready? Are they struggling generally? Is it mediation itself that they don't quite understand? So just sort of trying to sort of find out a little bit more about what's going on underneath to then work out, okay, if that's the case, what are the options, or helping them and pointing them in the right direction to get some advice.
Yeah, great. Thank you. Thanks, Rhiannon. Manny, I'm conscious this question's about finances, but equally it's the same scenario we get for children, isn't it? Quite often I want to sort out a problem and the other person's not engaging with it. Is there anything that you can add perhaps in relation to children matters that is an avenue here to consider?
Yeah, so I think with children, there is a tremendous amount of focus these days on resolving disputes out of court. And as perhaps a lot of people are aware about, unfortunately, the court system is backlogged. Each region has a tremendous amount of perhaps delay in between hearings. Sometimes when you need professional support and assistance, there can be delays in those types of reports. So the focus is to try and resolve disputes as best as you can and as early as you can. Now, there are a number of ways that can be done. So one really interesting way, I think, that has developed over the years is there's a use of certain apps and certain forums to enable parents to engage with one another, to set out proposals, and to try and resolve issues by agreement. There's also very interesting tools that some of these apps have and some of these platforms have with like calendars, for example. So if somebody's saying, I want the child on these certain days, or I'm going on a holiday on these days, it assists when you can visually see it and you can plan your own arrangements. You can incorporate other activities that you have to make planning and things easier. But also there's other aspects such as a draft parenting plans, where you can each in the dispute prepare a parenting plan and consider that. And then if you do decide to resolve the issues, there's a number of ways that can be done. There can be mediation directly between the parties and get involved. Either one or both of you may have solicitors. They will have a duty and also engage in correspondence and agreeing issues. And so there's many different focuses and ways in which mediation, particularly now when dealing with children, is really essential. Yeah.
Brilliant. Great. Thank you. I think we should move on to our second question that we've had. This one's got lots of different limbs to it, so I'll read it all and then I might break it into two chunks, actually. So I can't afford a lawyer, but my ex is taking me to court because she wants sole custody of our two kids. She has a lawyer because her parents are paying. Can I represent myself? How does that work? Is there any way I can win my case if I don't have a lawyer? Even though I do not have a lawyer, is there any other support I can get? And if so, from who and where? There's quite a lot of aspects of that to unpack, and I suppose the two strands are, how does it work if I'm representing myself, and then the second theme there is what can I do to make it as accessible for me as possible. So maybe if we take that first one, which is assuming you were representing yourself, entirely on your own at court, how does that work? Manny, I've just put you on the spot there. I'll take a little bit on this one, and then I'll pass over to you if that's okay. The courts are absolutely used to people representing themselves. It's a reality now. There is such a lot less legal aid than there used to be, that in sometimes the majority of cases, people represent themselves on one or both sides. So yes, you absolutely can represent yourself. Judges are used to it, and solicitors and barristers and other court users are used to it. It's not a problem at all. There are lots of resources that you can access to help explain that to you, things like Advice Now guides. And then we also have really useful links on our Stowe website that can help explain some of the processes to you. So in terms of how it works, you just attend the hearings the same as a lawyer would do, and you will get the opportunity to fill in all of the same forms as if you had a lawyer. So witness statements, position statements, if they're ordered, you can still do those, but you'd be preparing them yourself and explaining your case yourself. And there are rules that the court has to comply with to try and help you to do that. So the judges aren't going to be able to give you legal advice. That's not their role here, but they're very used to allowing people representing themselves to put their case forwards and have techniques available to help them do that. Manny, from your point of view, what would you add there about representing yourself at court?
Yeah, I think everyone involved in the court system or the family justice system is aware that it's a very difficult feeling that you might have if you're having to represent yourself, particularly if the other side is represented. I mean, feelings that you may have about that is completely understandable, first and foremost. But there is help there for you. So as Alice mentioned, since 2013, I believe in particular, there was legal aid cuts across many different areas of the law, and family law and private law disputes, so disputes between parents, was one of those that was impacted upon. So as a consequence of that, over the years, there's been a tremendous amount of online resources and websites to assist litigants and persons, first and foremost. And they can be very useful for a number of things. For example, accessing court forms or how to submit it, how to do guides. But also the gov.uk website, I believe, when you download application forms, there's often a guide attached to them as well that explains bits and pieces. The other tremendous, thing that has arisen as a consequence of legal aid cuts that helps people who are representing themselves there's actually quite a few charitable organizations, or different names, or different courts perhaps have a different relationship. So I've had some courts where there are duty solicitors or schemes. I've had some other courts where there's the national charities like Citizens Advice Bureau. When I was studying, there was something called Personal Support Unit. I think it's now Support Through Court. And if you have a dispute in a particular court, I would really encourage you to inquire with that court to see what service they're perhaps aligned with, whether there's a charity that might have a couple of rooms at the bottom of the court that can help with all sorts of things. They're not often lawyers, and that's the really important thing. So legal advice and practical support are completely different things, as well as emotional support. So I would spend some time researching what resources and maybe perhaps charitable organizations are available to give you that help that you may require, but also to emphasize that lawyers, judges, magistrates, court staff, court ushers, anyone within the court system, even perhaps even security, are very aware of litigants and persons and people representing themselves. And if you have a question or need help or something, just ask.
Yeah.
Many times when I'm a barrister, I see like a litigant and person on a completely different case, and they just say to me, look, is there a charity here? I've heard there's a certain charity, and I know because I'm familiar with the court, and I can take them to that organization. Or they say, well, I'm here for a case. I need to know how to sign in, and I could show them the usher's desk. So I would say people within the court arena are very aware of the challenges and the emotions that representing yourself can have, and definitely seek as much help as you require.
Yeah, brilliant. Rhiannon, I can see that you've mentioned before about some resources and places to look for help if you're not going to instruct a lawyer in the traditional sense. Is there anything you can add there about what somebody could do in those circumstances?
Yeah, so in fact, Manny, that's really helpful. I've been scribbling down here because I didn't know about the charity court, so I can let my clients know. So thank you for that. I'm learning today as well. So as you've both explained, going to court yourself, and that's called being a litigant in person, it is really daunting, particularly if the other side is represented, and you can often feel really on the back foot. And as you've both explained, there is luckily lots of resources, lots of help out there, and it's really important that people know. I wanted to, if it's okay with you, Alice, take a step back slightly and just sort of talk to the person who was going to be the litigant in person to say, please don't worry. The family court is nothing like the criminal courts. The judges are there to assist. Everybody's, as Manny has said, everybody's friendly, everybody's helpful. You know, we're trying to reach a resolution. This isn't about somebody's committed a crime and it's all going to be, you know, horrible and things like that. So don't worry about that. So yes, get the right resources. Yes, see if you can get some help. If it's somebody that you're going to take along to help you, such as a person called a Mackenzie friend is an option. So they can't speak for you, but they can sit next to you. They normally have experience in being in courts. They can tell you where to go, a little bit what Manny has said, but they're there for you all that day. But yes, know that you can ask questions and get the help there in the building. If you're not sure, there will be plenty of people to ask questions. So I think it can be very daunting. There are different options. You can't really have anybody speak for you if you're unrepresented, apart from in certain, my understanding is, and obviously both of you will know better than me, you might be able to, with the court's permission, get what's called a lay representative, somebody who can speak on your behalf, but you'd need to have organised that in advance, is my understanding. So you will need to speak for yourself. It's not that you can just take along your best friend or your sister and they can talk for you or anything. You would need to get permission if you're going to be taking anybody with you. But yes, the big thing for me, if you are going to be a litigant in person, is you'll be okay. You just need to be prepared, know what to expect from that particular hearing, know what's expected of you at that hearing. And as you've both said, there are lots of resources out there to help with that.
Yeah, and just touching on the Mackenzie friend, it definitely seems like there's a lot more than when I first started in practice. They're becoming more and more common. And to explain what they are, their role is to give you practical support in court. They can take notes, organise papers for you, and things like that. They can't talk to the court or address the judge, and they need to be somebody that's suitable. So they shouldn't really have an interest in the outcome of the case. And they need to not impact the smooth passage of justice. So bringing in, I don't know, a new partner where they're part of the dispute in a children case probably wouldn't necessarily be appropriate in general. But if you brought, I don't know, a sibling or a best friend who wasn't connected so closely but could give you that practical support, and importantly, who understands the confidential and private nature of these proceedings, then that might be somebody more suitable. It's a real generalisation, but just make sure you're thinking about how appropriate they are to bring along. I can also see a note on here, Rhiannon, as helpfully put in our notes that we've got about direct access barristers. And Manny, I wonder whether you could just explain a bit about that to people who might not know what they are.
Yeah, so direct access. So sometimes, often when people have lawyers involved in cases, they have a solicitor and they also have the barrister. So the solicitor instructs the barrister on your behalf. There are barristers who can obtain the necessary training and accreditation to be direct access. So you, as a member of the public, can get representation from the barrister direct at court. There are a number of rules in existence, including ethical rules, which are actually quite complicated about what barristers can and cannot do. But barristers, basically, if you do approach a direct access barrister, so for example, my chambers, I think on their website will have a page saying direct access, and as much information as possible from the chambers and the regulator as to what the scheme is and how it works, and the form perhaps you've got to do. I mean, I think there's many reasons why people might choose to go directly to a barrister. I often hear it's sometimes, I don't necessarily say one way or another, people might say it's cost effective. It's perhaps more cost effective to go directly, just you only need assistance with the representation. But what I would say is it's very, solicitors in particular are very aware of the scheme. There's pros and cons to either going direct access or going utilizing a solicitor and a barrister. And so each case is very different. And so I would also encourage, if people are contemplating whether to go to a solicitor and to instruct a barrister, or even to have the solicitor who can represent you as well in court with no barrister, or going to a barrister direct, to look into the pros and cons for you in your particular case and what stage you're at. There are many pros and cons to all options, really.
Yeah, perfect. Yeah, I mean, I know from my practice, quite often I'll speak to someone, they'll come in and see me for a bit of a one-off MOT on their case and what's going on it. But say, look, I can't really afford you. It's expensive, and I think I'm in for the long haul here. And then sometimes we'll, like I say, put you in touch with a barrister who can do direct access, or other times we can offer something called unbundled, which is where we act on a limited part of your case. So there's loads of options, and probably the best answer there, because it's so fact specific, is to reach out and speak to either a clerk, to the barrister if you've got a specific hearing you want cover for, or to a solicitor to take a bit of advice on that. I can also see somebody's mentioned pro bono work here. I'm not sure if that was you, Rhiannon, but that's also a really good point to flag up. There are lots of organisations that have lawyers who will give free time to helping and supporting. So universities and further education institutions, solicitors and barristers firms will sometimes have links to pro bono units. So that kind of falls into what Manny said earlier about charities, but there are those resources out there to go look for. Okay, it's probably time for us to move on to the third question that we've got here, if that's okay, unless anyone's got anything else to add there.
No, just to say, for pro bono, one really good organisation is called Advocate, so capital A, Advocate. They're really good. You fill in a form and they handle the rest, and they've just got a great system in place.
Yeah, brilliant. So yeah, things like that, law works, those kind of things. And again, we're helped today by the fabulous Susie, who's busy popping links in the chat. So if we're talking about things and you're thinking, oh, I meant to write that down, have a look in the chat, because there's links in there already. And don't forget, you can pop any questions you've got in there too. So jumping on to this third question. The third question is, I need to go to a court hearing, but I have been in an abusive relationship and I'm scared of seeing or being around my ex. Is there anything I can do? Who can I talk to about this? This is a really, really common question that we get. Again, Manny, probably in terms of the actual in-court stuff, I might turn to you first and ask you what you can add to this one.
Yeah, so again, similar to what's been echoed before, the courts are now very accustomed to issues that can arise, not only generally within the case, but also within the court arena. And there are a number of stages. So the family courts and family lawyers and everyone involved in the family justice system, including other professionals as well, are very aware of the impact upon abuse, the impact upon allegations, the impact upon vulnerability, the impact upon you feeling comfortable at court, and the impact that could have on you presenting your case. For example, if you feel scared or not safe and you're representing yourself, that of course will have an impact on you. So hopefully there are a number of ways that can assist you. For example, there are what we can call special measures that are in place that can be arranged directly with the court, and you should contact the court, or at the hearing, judges will ensure it's within perhaps the court order as well. It's required to be looked into all the time. And that's things like, I have to say, it's very, again, court specific, because certain facilities are only available in certain courts, but generally they're accustomed and kitted out for protection. So, for example, in the courtroom, there can be a screen available, complete screen, so you cannot see the other side. The judge can see you, but you can't see the other side. And that can be when you're addressing the court or when you're giving evidence. There can also be separate waiting rooms, confidential waiting rooms, or separate entrances into the court building. So you're not going to bump into somebody in the waiting room or the queue to get into court. So what I would say is, firstly, if you have raised concerns and you do feel scared, as per the question, being around your ex, yes, there's so many things that can be done for you. And the court and the lawyers involved have an actual, if there are lawyers involved, have a duty to assist. And the court staff are very much aware of facilitating these requirements that you have. So it's really important you speak up and speak to the right person, whether that's the court, whether that's the judge, whether it's your lawyer, the other lawyer on the other side, or the court staff, to ensure you get the help that's required to feel comfortable in the court arena and environment at all stages.
Thank you. So I suppose that's the legal perspective on it, but possibly even more important, Rhiannon, is kind of the emotional side of it and the bits that are more your area of expertise. Can you tell us about any tips you've got on this question?
Yeah, it can be very daunting to think about going to court anyway for any of us. But if you have been a victim of any type of abuse, then obviously, you know, you can feel very worried and nervous about having to actually see your perpetrator. It might be the first time you've seen them in a long time and you're having to see them in this formal court arena. So as Manny said, my main piece of advice is always speak up. So don't feel, you know, if you are nervous, even if you don't, a lot of people don't recognize themselves as having been victims of abuse. It's important to tell, if you do have legal representation, you do tell your solicitor, and if you don't, as Manny said, you inform the court, because there are facilities in place, these things called special measures, etc. So speaking up and doing the best for yourself, and also knowing that you don't have to do it alone. So your solicitor will be with you all the way. You know, they will be with you. They won't leave you on your own. They'll tell you where to sit. They'll tell you where to go. And the same with a barrister if you've got direct access, for example, and you don't have a solicitor there. So they will look after you, but you've got to let them know, first of all, that you do need that support. They'll probably recognise that because they'll know, obviously, the nature of your case, etc. The other thing is that there are particular professionals that can help with if you have been a victim of abuse. And I don't know too much about how to find them, but I just thought I'd sort of put it out there. They're called Independent Domestic Abuse Advisors, or IDVAs. And my understanding is that, because I've had a couple of clients that have worked with them, they can go to court with you. They are trained and specialised in supporting people who are victims of domestic abuse in court. So it's worth, if you are a victim of domestic abuse, if you're going on your own in particular, to look into the sorts of help you can get from these types of people. But it's just making sure that you don't feel alone, you don't feel vulnerable as much as possible. Do tell people, because there is help and support out there, and hopefully you can be pointed in the right direction then to feel as comfortable as you can in court.
Yeah. That's great, thank you. I think the only thing I've got to add to this is that quite often the thing that I hear people being worried about at court is cross-examination. So being asked questions by the other side, and particularly in cases where people are both representing themselves and there has been abuse in that dynamic, there are particular rules that apply in those circumstances. They can be quite technical, but in general, there is a prohibition on cross-examining somebody who is either the victim, complainant, or perpetrator in certain circumstances. So that can include where somebody's been convicted of a certain kind of offence, and in cases where there are certain types of allegations being made, or just where it's going to affect the quality of the evidence you can give by being cross-examined by these persons. Then it can kind of unlock a raft of measures the court can do. And that can include things like the judge putting questions that have been written down by the other side, or in some circumstances, somebody called a qualified legal representative, a QLR, asking those questions for you. And a QLR, they're not a barrister that's hired for you, but they're usually barristers who are putting the questions that the person who's been accused wants to put, or vice versa. But in a way that is less traumatic than being directly questioned by somebody who's perpetrated that abuse on you. So, you know, that's several steps down the line. But if you get to the point where you have to give evidence, it may well be that you benefit from the rules that exist there, and that the person who you're saying has perpetrated these abuse on you isn't going to be allowed to challenge you on those allegations, that it might be somebody else that does that. And that can be quite reassuring to know that that safety net's there, and you might not be put through those circumstances. So there's a whole raft of protective measures that are there. Moving on to the next question that we've got. So this question is, I don't want to go to court by myself. Can I bring a family member with me for moral support or to speak to the judge on my behalf? And if I have a lawyer, will I actually have to say anything, or will they do the talking for me? Rhiannon, I don't know whether you want to take this one first.
Yeah, so the courts have quite strict rules about who they are comfortable taking, having in the courtroom. So family proceedings are sort of private proceedings. So you can take absolutely a family member or a friend with you to the court, but you'd need to have permission from the judge and the other side, so your ex's team, for you to have somebody in the courtroom with you. So it's just worth bearing that in mind in advance, so you don't, you know, suddenly find out and feel disappointed that your friend can't be with you. Not many court hearings require, if you are represented by a solicitor, a barrister, not many court hearings, if any, are you expected to actually speak. So that's worth bearing in mind. I think a lot of people don't realise that. So there's really only, you know, a fact-finding hearing or a final hearing where you may be asked questions, and we've talked about cross-examination that a lot of people have probably heard of. So if you are represented, you probably will just need to sit there in body, as I tend to say to clients, you just have to be physically there. So that's worth remembering, because I think it can make a big difference whether you feel you've got to speak to the judge or whether you know you can just sit there and take more of a passive role. I think that can make a big difference as to how nervous people can be. And as I said, if you want somebody with you, you would have to have the judge's permission in advance to have them in the courtroom itself with you. But yes, it's just worth remembering, because it's amazing how many people don't realise that they're not going to have to talk in court in most hearings. And once I've told them that, they're like, oh, right, okay, that's fine then. My lawyers are in charge. They'll do everything for me. So I think that can make a big difference, knowing that.
Yeah, absolutely. I mean, if you're paying a solicitor or a barrister, that's kind of what we're there for, is to filter that out and do that bit for you. Even if you are representing yourself, quite a lot of the time, the points you're going to have to talk about are very clear before you go into the hearing, because the process leading up to a court hearing is about trying to filter out what can we just agree on that we don't really need to trouble the judge on, and what bits do we need a bit of help on here, whether it's about children, money, or something else. So you know, it's not so much all sprung on you on the day and unfamiliar territory. You would normally have the chance to prepare yourself a bit before. Manny, what would you like to add to this question?
Yeah, so that's really key. The aspect, again, I think it's always very useful for people to have emotional support in the waiting room, waiting for hearings, etc. I think when you are represented, one thing to say, yeah, you often don't speak in court because your lawyer who you've paid for or who's representing you will do the speaking on your behalf. But also, if there's something you really need to say to your lawyer during the hearing, so the judge asks a question or asks something that you're not necessarily confident your lawyer may know because that question was unexpected, you can communicate with your lawyer. You obviously got to whisper, you don't want anyone to hear. Or, as often in my cases, my clients will have like a notepad and they can write it down, or some sticky tabs. And they're often either sitting with me or just behind me, and they'll just pass it over. So you can, if anything crops up, just because you're not speaking, you can still get your instructions out there one way or another.
Yeah, I think so. And I think, like all these things, it's unfamiliar territory. People very rarely go to court, and a lot of the time, family proceedings, the first time that somebody is in that environment. And you know, the language is different, the dress is different, and it's totally normal to feel a little bit shocked and perhaps out of your depth when you go into there. But the more you can research before, things like knowing what to call a judge. If you don't know what to call them, just call them judge. You won't offend them. We can call them sir or madam. Things like what an usher does or what a clerk is, things like that. You can literally Google these, and then it makes you more familiar with the environment you're going into. Okay, so I can see as well, just another point of expansion really on that question. What will the judge wear and what does a courtroom look like inside? I guess we're all quite familiar with that because we deal with it on a regular basis. Manny, do you want to talk us through what a courtroom's like on the inside?
Yeah, so each court, again, unfortunately, is very, 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 very different. Some courtrooms are massive. Some courtrooms are very, very small. But where there's issues, so for example, where there's going to be what we call a hybrid hearing, where maybe one person or someone is online and the other people are in person, that can happen as well. Courtrooms may be a bit bigger. You may shift through to a different courtroom. Equally, where there's a number of people in court, that you might be moved into a bigger courtroom. But how it basically is normally you can't just physically just go into a room. The usher or court staff will always usher you into the courtroom when the judge is ready to hear your case. You go in, and normally the usher would go in with you and tell you all where to sit. If not, your lawyer, or if you don't have a lawyer, it will definitely be the usher will tell you, sit here, sit there. Some courts actually have quite different traditions, but normally the applicant or the person making the application sits on the left-hand side, and then the respondent on the right-hand side. But again, it depends on different courtrooms. The judge will be sat right back under the big crest. And then what happens is the judge might be in court already or might not be in court already, and comes in and you all got to stand. There's also different levels of seniority of judges. There's also magistrates, and depending upon the seniority, they have different titles as well. But I agree with Alice, call them judge regardless of their seniority. And in terms of what they wear, so typically judges just wear smart attire. In London, there are a couple of courts that adopted a policy, and judges wear a full judicial attire, their robes. And regardless of the level of court, that does exist in some particular courts here in London, but generally judges will just wear their suit on, just like me, just a tie, a shirt as a male, or smart wear generally. And the environment is not as intimidating as you perhaps see on TV. And normally in the courtroom, there'll be the judge, the usher, and then the people involved in the case. Yeah.
Brilliant. Great. Thanks, Manny. Okay, so the next question that we've got, well, this is probably more my territory actually. What is an FDR hearing? How likely is it that that will work? I'm worried that my ex won't engage with financial matters. So financial court proceedings, assuming you've tried all of those things we talked about before, so mediation, trying through solicitors, sometimes trying to discuss things directly, looking at other things like collaborative law or any other way of breaking it, and you really can't sort it and you end up in court. There are three main court hearings. The first one, it is a first appointment. It's about making sure all of the information you need is on track, and that any other expert evidence you need to make a decision about the case is done. So the first one's an admin hearing, really, to get everything off on the right track. The next hearing after that is your FDR, and that's what this question's about. So an FDR is off the court record. It means that you couldn't tell a judge at the final hearing what happened there. And the aim of that hearing is for you and the other party, with the help of the judge, to try and negotiate an agreement. So it's not a hearing in which that judge can say, well, you've tried, you can't agree, and I'm telling you this, what happens. The judge's role there is to facilitate the two of you negotiating. And the judge does that by giving you what's called indications, so their opinion. In terms of how likely it is that it works, FDRs have really good success rates, and they're, you know, I know certainly in practice, I tend to say to people, look, if you're doing one through the court system, you're probably talking about 80% plus chance of it working and you settling your case on the day. If you do settle it on the day, then a lot of the times you'll leave with a court order that day that says, this is what we've agreed, and that's the end of our claims against each other. So it can be really good at wrapping things up. If it doesn't work, or if the other person doesn't engage, then you would go on to the third step, which is a final hearing, usually where a different judge on a different day would hear evidence. So that's when there would be things like cross-examination, and would then make a decision for you about what would happen. But you can still settle at any point up until that final hearing. And a good lawyer will always encourage you to try and do that, just because something that you've agreed yourself can often work much better in practice than something that a judge has decided is going to fit your circumstances for you. Rhiannon, is there something that you want to add there about how to deal with it when somebody won't engage, and how to cope with the FDR process?
It's something actually that I go through with clients quite a lot, which is how to prepare. So I'll take it sort of separately, how to prepare for an FDR. So I tend to have sessions with clients on that. So my top tips of how to prepare for an FDR is be aware that it's going to be a long day. So you're probably going to be there most of the day. So be prepared for that. Have things in place, have sorted out childcare arrangements in advance. You're not rushing off. And one of the things, it might sound a bit funny, but one of the things I often suggest is take snacks, because a lot of the courts are not very good on having facilities. So make sure you're hydrated. The snacks I always recommend are things like nuts and chocolate, sort of to keep, you fueled up and everything, because it can be sort of quite a long day with negotiating. You're not in court for that long. You're not in front of the judge for that long, rather. You'll probably be in a meeting room with your team, so you are able to then eat little bits and pieces and that sort of thing to feel comfortable. Your legal team are there obviously to support you, but you're the decision maker. So it can be quite daunting to think, well, what if my ex isn't going to come to the table to negotiate? In advance of the hearing, you will have put forward proposals so that you know sort of how far apart you are with the negotiations. That can be quite helpful. And then the judges, it's very much frowned upon if somebody clearly is being very stubborn and they're not moving. So if your ex is stubborn but they have legal representation, hopefully they'll have the positive influence of their solicitor and barrister to try and unlock that and to explain to them the benefit, as you've explained, Alice, of reaching a settlement and how that is in both parties' best interest. But it's having confidence in your legal team, knowing that you've got a good proposal ready, and you being open to negotiating. You're not responsible for your ex and how they decide to behave or deal with the day. So just focus on being solution focused, keep a positive mindset, and take chocolate and nuts with you. That's my advice.
Brilliant. I might have to take that one, Rhiannon, next time I'm at court, take some chocolate and nuts. We've got a few live Q&As, so that there may still be time to take a few more than the two that we have already. So if you've got more questions, do pop them in there. So I'm going to turn to the first one here, sort of condensing it down a little bit. This question's about a case where mediation's broken down because parties can't agree whether they need a pension expert report. And it sounds like court proceedings have come out as a result of that. It's going to cost £3,000. And the other person says that the pension sharing report is necessary, and that the person asking the question should pay for it. They're in court next month and they're representing themselves. The question is the judge likely to make a clear ruling at an initial hearing on whether somebody should pay for a pension expert report or not? Okay. It gets really fact specific, isn't it? Because it depends on what the rest of the assets you've got are. Yes, the judge will definitely make a clear decision on the day, I would say, about whether you need a pension report. A lot of the time there would need to be things like CVs for the expert the person was suggesting, and a draft letter setting out the questions that they want that expert to answer. General rule of thumb in family is that the costs are split equally, but there are circumstances where the court can depart from that. So, if it was the case that you've won the lottery, you've got millions of pounds, and your wife doesn't work, hasn't got anything at all, then probably the court's going to say you need to pay for it. If all things are equal and the court thinks it needs that report to get to the bottom of the case, the test for that is whether it's necessary. And we have case law that says necessary means necessary. That's literally the rules that we're going by here. If the court thinks it's necessary and all things are equal, they might say it's 50-50. It just really does depend on how the rest of the assets sit. Manny, I know you're primarily children focused, but have you got any input on experts' fees in court proceedings?
Yeah, so it often depends. So what this application will be, I think, a Part 25 application, right? And as part of the application, there's various things you've got to comply. So in that case, the other side will have to compile and prepare the application. And within that, hopefully, you have the submissions in respect of how the division of costs for the expert should be split down the line, or one party should pay it. But yes, that's the judge's task at the first hearing, to make that determination, which includes A, is it indeed necessary? B, if so, who pays for that expert? So definitely, I think there'll be arguments can be had in front of that judge, who will have to deal with it.
Yeah, great, thank you. So really, at the risk of us saying it depends on how much money both of you have got, both sides, that's probably what it will boil down to there. But the starting point is that you'd pay half each for an expert. The next question that we've got: I've applied for financial remedy. The case is listed at my local court. My wife lives 300 miles away and has applied to the court for the hearing to be heard by video. Is this likely to be agreed by the court? Rhiannon, first of all, is there anything you can say about how video hearings have been working and the impact that you see that having?
Yes, it's varied really. I mean, obviously, I think since COVID, we're all much more au fait about working online, and that includes the courts. I always suggest to clients that if they can physically get to the court, if it's an in-person hearing, they should try, because it does make a difference if you're physically there. So I have had situations where unfortunately my client, the tech hasn't worked properly and they've lost sound, and they then feel on the back foot in what's going on in the court process. So I think it is always difficult where, one party's got to travel quite a way, but if that other party can get to the court, I would suggest, or make sure you've practiced the tech in advance in whatever way possible. So making sure you understand, don't just try and log on, minutes before your hearing's due to start. Make sure that you've read the instructions that the court will have sent you, and you've, or got somebody who can help you set it up so that you feel you're in an equal position to the person who's actually physically at court.
Yeah, great. Manny, what would you say on this one? How likely is it that 300 miles away they'd be given permission for video hearing, and how does CVP work in practice, which is what we usually use?
Yeah, so I think the judge in that case is a financial remedy court, has a number of options. It might be the easiest option for everyone to be remote. Perhaps that could be a determination by the judge. It doesn't necessarily have to be the case. So that if one of you is in person, one of you is remote, that'll be hybrid. CVP is a particular tool utilized for court proceedings. It's a link you can access for your web browser on Google Chrome. As Rhiannon said, that it's very important you read the instructions. The court actually do send it. One thing I should say from experience is some courts are different in terms of when you actually get that link. So sometimes it might be just before the hearing. Sometimes it might be a day before, 2 days before. It causes anxiety to me to this day when I don't have a link. And I'm like, oh, what's going on? But what I would say is 300 miles away is quite far. But they have to make that application, and they have to get to the relevant person to make that determination in advance. What I would say is when the hearing has been listed, there will be a very clear notice as to whether that hearing's in person. And if one party doesn't want it to be in person or to be attend remotely, they theoretically have to apply to the court for permission to attend remotely. So they've got to get through those hoops first and foremost.
Yeah. Brilliant. Yeah, I agree with you there, Manny. 300 miles and it's a first appointment. My gut instinct is probably they'll give somebody permission to do that one remotely, but it is, we say, is case by case basis, and it's in the discretion of the judge what they think's appropriate there. We've got a couple more questions. Let's have a little look. I'm going to go out of order slightly because this one's a good one. My ex and I can't agree on child arrangements. If we end up at court, would my children have to attend? They are 11 and 9. Manny, this is your territory firmly here.
No, but what I would say is, I don't know if the courts still utilise this, but there are courts where when there's a first hearing, what we call a FHDRA, first hearing dispute resolution appointment, there are courts that have operated a scheme for a while for a child of a certain age. I always forget whether it's 8 or 9, comes to court at the first hearing and is spoken to by CAFCAS. So their views can be ascertained right at the beginning as part of what we call a safeguarding letter. That's quite complex. It's quite rare. As I understand it, only certain courts did it or do it from my experience. But ordinarily, no. If you end up in court, will your children have to attend? No. 11 or 9, unless the court operate that policy, I believe not. What I would say, however, 11 and 9 are ages in which the children's views are important. So if the proceedings do continue, there is a potential the children might be involved in the proceedings in different ways. For example, if there's a welfare report, such as a Section 7 report by CAFCAS or an independent social worker who may have to ascertain the children's wishes and feelings, and the children may do a letter or something like that. So they can participate indirectly via different ways. I do have a book on the children participation in family law proceedings. So the participation of children in family law proceedings, so that's the right title, came out last year. If anyone's interested in that, it's on Amazon. And that deals with various ways in which children are directly or indirectly involved in proceedings relating to family law.
Yeah.
Can I ask you a question, Manny, what you've just said? So you mentioned that at a first hearing, in some cases, the children might be questioned by a CAFCAS officer. Would that be in court, the room itself, or would it be in a separate room?
It will be in a separate room right near the court. So this particular court that I'm thinking of, where I've had this particular experience, is the court will be on a certain floor, and CAFCAS would have a room allocated. And that day, the CAFCAS would make contact in advance, asking the person with the child to come in during that time. It's a very short meeting, but it's just part and parcel of the recommendations that CAFCAS sometimes are required to provide, well, they have to provide the court through what we call a safeguarding letter. What I should say, the caveat to this is there are many locations now and courts where there's something called the Pathfinders pilot. It's not in my area where I primarily practice. So I think, Alice, actually, maybe in your area, doesn't it?
We got it in Birmingham, yeah.
Got it in Birmingham quite early, which has a very different, unique and interesting way. I actually don't know whether CAFCAS speak to the children as part of that. But where I'm from, where they still utilise what we call the safeguarding process, there's particular courts where that does happen. But other than where I'm from, I've not seen it utilised elsewhere. But as Alice will probably explain, the Pathfinders pilot has very interesting ways forward in that respect.
Yeah, so Pathfinder, don't worry about it unless you've seen it. If you're in a Pathfinder court, your first court order will have the word Pathfinder somewhere on it, and you'll see that it's relevant to you. So don't worry about looking into it unless it directly affects you. It's a pilot, and it's about getting the reports and people to speak to children and get their wishes and feelings earlier on in the process. So before you even come in for your first court hearing, there's more groundwork done by CAFCAS, who are basically the social workers for the court, if you like, before you even get through the court doors, so that the judge on that first day has got more information and you've got more insight as to what professionals are thinking. And the aim is that it gets you through the court process quicker. So if you are in a Pathfinder area, there's loads of information about it online. And I'm sure if Susie can have a look on our website, if we've got any articles on it, she can link those in the chat for you to have a look at. If it doesn't say Pathfinder, don't worry about it. Again, just look at any resources you can about the children proceedings and how those work, and you'd be on the normal track, if you like. It is just a Pathfinder project pilot in a couple of areas in the country that they're trying out at the moment. Another question that we've got, this one's a relatively brief one. I've moved abroad to be with my family in my home country while my divorce goes through. Can I attend court from another country? Yeah, absolutely, you can do. Manny, I don't know whether you want to touch on that one.
Yeah, so you can. The issue is whether you're permitted to do so, though. So theoretically, you can. You've got access to the internet. You can. However, again, if there's a hearing and it's already been specified what's required, you may have to make that application directly or seek the agreement from the other side and then inform the court and get permission. So don't just chance it. You've got to go through the right hoops to get permission.
Yeah, absolutely. I mean, in practice, the court's quite used to it. I guess particularly where you are in London, Manny, you get a lot more international than in other areas of the country because of the demographic. I've acted for people across the world, and it's never been a practical problem. If there's a hearing you really need to come over for, it's about trying to make it practically work. Okay, we're at 24 minutes past 6, so I think this is probably our last question. This is another one from the chat box that we've got. So it says, my spouse is being investigated by DWP for benefits fraud for failing to disclose savings accounts. Is this relevant to our financial remedy hearing in terms of any concerns I should raise about full disclosure to the Court of Assets? Okay, so I mean, there's a lot going on here, isn't there, to unpack? So I suppose the question here is, how do I deal with it when someone's not disclosing, or I've got an inkling that they're hiding things, but I can't quite put my finger on it. Rhiannon, what have you got to add on how to deal with a non-disclosing spouse?
It happens a lot, doesn't it, that either there is non-disclosure or one of the parties is suspicious that there's been non-disclosure, and that can be quite tricky. So financial disclosure is done by way of this form called a Form E. So it's quite a comprehensive form, isn't it, to sort of provide all the information, but you can then ask questions. So you don't just have to rely on what the person has provided. You can ask questions about it. And you can also get, if you're in the court process, court orders for them to have to provide any missing information. Some of my clients have asked, are there professionals you can hire to investigate the financial position, the true financial position of their other half? There are these people called forensic accountants. I always sort of suggest being a little bit careful. They are quite pricey, these professionals, and you would want to do it only if you really thought it was necessary. With things that the courts don't tend to get too involved in sort of what I call shopping somebody to DWP or to HMRC. So they're tending to look at in the family courts the bigger picture. So you can tell your solicitor everything. If you do have concerns that there is money that's been hidden, or if something isn't quite right, do tell your solicitor, because they are in the best position to be able to help you in working out, is it necessary for us to move forward with, you know, formal investigations, etc. But it is always tricky when there has been non-disclosure. But yes, your solicitor is your first port of call to find out what are the options available if I feel that my other half is not providing the right information.
Yeah, absolutely. I mean, it is really relevant, both from a point of view of, is there going to be a big debt from DWP for this being claimed back, which I would guess your spouse is probably quite keen to account if that is the case, but also, are there really hidden savings accounts? And like you say, part of the process is a little bit investigative. You get a chance to raise a questionnaire, so a list of written questions after you've done your Form E. And you can put it in there. If it's still not properly answered at that point, you can raise something called a schedule of deficiencies, or apply to the court and say, look, this new bit of information has come to light. And it's really important, actually, that you order him to do a statement or something else to show me what's going on here. We also quite often update disclosure throughout a case. So if you've done your disclosure in the January and you have a really big hearing in July, probably in June, you're going to be updating it, providing more bank statements. Practically on the ground, a lot of the time when we find hidden assets, it's in the bank statements, it's transfers between accounts, it's where on earth are you paying for your food shopping because you've never shopped in a supermarket in your life and you haven't got a credit card, so it's got to be coming from somewhere. Those kind of things. And a lot of the time it's experience, but also you will know your spouse's finances. You'll know what's normal for them and what's not. Things like pensions quite often get hidden, and you might think, well, hang on, you worked for the NHS for 10 years and you're saying you have no pension, and you'd raise a question about it. So it's a combination of some detective work, whether it's by you or a solicitor or a forensic accountant, or even in cross-examination by a barrister, and what you already know about this person and their finances. But yeah, absolutely, that should definitely be raised and got to the bottom of, if for no other reason than you're probably not going to be able to focus on settling it until you've seen what there is to see there. Manny, is there anything else that you wanted to add on that point at all?
No, not at all. I agree with you both.
Yeah, perfect. Well, I can't believe the time has flown by, and we're at 28 minutes past 6 already, and we've had loads of really useful and helpful questions there. An enormous thank you to both Manny and Rhiannon for giving up their time this evening and their vast expertise and knowledge to help answer all of these questions. I think it's been really helpful, and I hope you've picked up some good tips. Also, massive thank you to Susie, who's been moderating our chat and popping all those helpful links into things like Manny's books and I think some links to Rhiannon's website and Stowe resources that might be helpful for you there. Our next breakup club is going to be in September, so keep your eye on your emails for the subject for that. We've also got a live podcast next week, which is hosted by Stowe Talks' Matt Taylor and Lisa Gattrell, so please do join us at 12:30 on Tuesday the 17th of June for a live Ask a Family Lawyer. Susie's going to pop a registration link in the chat box, and as ever you can send in your questions ahead of time, and that would be to stowefamilylaw.co.uk. So I think all that remains is to me to thank you for you giving your time to listening to us, and again to thank Manny and Rhiannon for their help this evening as well. Thank you, everybody. Evening all.
Thank you. Thanks.